BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, everyone. Greetings from us to everyone who is tuned in, watching us from all over the world. You are welcome to Heritage TV, hanging out with BWF Solicitors, with your usual host, Vicky Newton. Today, I'm hanging out as usual with Mrs. EUSS Champong. Senior, she's a partner at BWF Solicitors and also a solicitor at BWF Solicitors. A very big thank you to BWF Solicitors making it possible for us to come your way every Saturday 12 noon, and also Victon Estates and Eagle Heights International School. Before I tell you what we are going to talk about today, I just want to say a belated happy birthday to Oli, who is EUSS Champong's son. He had his birthday yesterday. So happy birthday, little Oli. And also a big happy birthday to the CEO of Honey Hemis, Amanda. I hope you had a lovely birthday yesterday. So yes, we're going to talk about applying for EUSS family permit after 1st July 2021. And with me, I think I've mentioned her name already. Let me introduce her quickly. Mrs. EUSS Champong. Hello.
Hi, Vicky. How are you?
Hi. I'm fine, thank you. And you?
I'm doing very well.
I hope you had a very nice time with Oli and the family.
Yes, he enjoyed his grandma's place. He had football. So, yeah, he enjoys his football. So that was good.
Wow, amazing. Let me also tell our viewers to also share this live program. If you are at work and you feel you cannot join us through the program, this program will be available to you on all our social media handles, at Heritage TV and also at BWF Solicitors platform. I realize that every Saturday when we have our legal education program, I get so many calls from all over the world, especially Europe. People saying a big thank you for the education we're giving them, prompting them, letting them know what is going on. So I will not take the praise alone, but I think without BWS solicitors and lawyer Eunice, this wouldn't have happened. So I'll also share this with lawyer Eunice and her team as well. Like I always request, please send in your questions. This makes the program very interesting. So please share, and send in all your questions. Send in your question, and you feel you don't want us to mention your name when discussing your questions. We'll be very happy to oblige. We'll not mention your name, but all we are doing is to educate ourselves. If you have any problem or you're going through any application process regarding this topic, this is the only time, and it's free of charge to you, for you to send in your questions for us to delve into it. If you prefer to call us live during this program, please call us on 0744 8619 711. The number again is 0744 8619 711. And I hope Lawyer Eunice will always make justice to whatever question you have for us. So, Lawyer Eunice?
Hello.
Yes. So now the spotlight is on you. Any updates before we delve into this topic, Lawyer Eunice?
Okay, so Vicky, as we all know, today is what? It's the 26th of June.
Oh my God.
So we have only 4 days till the 30th of June, isn't it?
Yep.
Yes. And so as much as possible, I think a lot of awareness has been raised by the government with advertisements, with them telling employers, local authorities, vulnerable people centers like the care homes, and even those day centers where usually you have youth going to. They've tried to inform as many organizations and institutions as possible so that people can then make other, should I say, users of those facilities aware of the fact that there is something called an EU settlement scheme which you are supposed to apply to. And so, as much as possible, we as lawyers as well have tried to make people aware of this deadline. And all it is basically that the EU is an institution or an organization on its own, and Britain has decided to leave. And therefore, its laws do not regulate the UK any longer. And in order to protect our EU nationals and their family members, and those that have retained their rights or those that have derivative rights, the UK government have said, we will protect you by creating this EU settlement scheme, which will then allow you to live and work in the UK legally. So, of course, if you had any sort of residence card or registration certificate or permanent residence based on the old law, so we have the Immigration EA Regulation 2006 and 2016 that granted people those that were living in the UK, such as EA nationals and their family members, residence cards and permanent residence. So, unfortunately, because that law or those laws will no longer be enforced, it is important that those people now have something to rely on or something to protect them whilst living in the UK. And that's why the government has come up with the EU settlement scheme. And so, as much as possible, they're saying, regardless of whether you have a registration certificate, regardless of the fact that you have lived here over a period of, let's say, 15 years, 20 years, regardless of whether you have permanent residence card, as an EA national or a family member of an EA national in the UK, please do apply under the EU settlement scheme so that by the 30th of June 2021, you will still be seen as somebody who is allowed to stay in the UK. So somebody who has lawful residence in the UK. And unfortunately, if you are not able to do so by the deadline, you should know that it would be as if you were an illegal immigrant, unless you have reasonable excuse why you were not able to make the application by the 30th of June 2021. And I think that a lot of people are now aware because of the fact that their employers, for instance, will be alerting them on it. Have you
Yeah.
got your settled status? Can you provide us with evidence of this and the rest of it? And so, of course, I know people have been seeing the adverts by the government as well. So we're trying to make sure that people are aware, but you will still have people come through the sieve and they will still say they did not know or they didn't they weren't made aware that there was something called EU settlement scheme that they were supposed to apply to, or people even with permanent residence, because they think that they have permanent residence, so they're not supposed to apply to the scheme. So you will have all these people who would say that they were not made aware or they didn't know that they were supposed to do something called an EU settlement scheme. And so it helps that under the reasonable grounds for which somebody can make the application after the 30th of June, they have put there that there will be compassionate and compelling grounds. So it must be evidence. So you can't just say, oh, I didn't know. Do you work in a place where these checks are made? And if, for instance, you were not made aware, then of course you can rely on the fact that you were not made aware, and maybe it was brought to your awareness by a friend or your employer later on, and that is why you are now making the application for the EU settlement, pre-settled or settled status. So as much as possible, we should adhere to the government's deadline of the 30th of June. Otherwise, you should be able to evidence whatever reasonable excuse or ground you may have for not making the application by the 30th of June, which is next week, Wednesday.
If I should chip in, I just would like to applaud BWF solicitors for the extensive, discussion on this particular, issue. Why am I saying this? There are some people in other Ghanaian community who English language wasn't their first mother tongue. So it's only the local Tree dialect that they are comfortable in. So with BWF going on all the Ghanaian media platforms, educating people in the Ghanaian language is, conscientizing a lot of them, making them know that, look, I have to make this application, put this application before the deadline. So I would like to applaud you. I've been, following the discussion, following you on all, all your social media handles. Anytime you go on various radio platforms, I've been following, and I can see how people are now aware of. So you don't have any excuse to say that, as for me, the English, I don't, understand the English. I can only speak Chi or Ga. But, going on these platforms has really helped a lot to make people aware that they need to put in this application by the 30th of June. So thank you so much. Thank you so much. Yeah. Over to you, Laura Eunice.
Thank you. So yes, of course, this is something that we are making sure that as many people as possible will share and give to a friend, because if
Mm-hmm.
you if you look at the way our life is here in the UK, a lot of people work and come home. So it's work,
Yes.
and then if you have a
Yeah.
family,
Yeah. Yeah.
the family, and then home to sleep, and then back to work again. And so,
Yeah.
because there is that constant cycle, people don't have the chance to really watch TV per se. Um, we are very, should I say, a technology um,
Savvy.
based on people. So we do tend to have our phones quite often. And so
Mm.
even if we don't have the TV, sharing it to somebody on WhatsApp, sharing it to somebody on Facebook, sharing it to somebody on YouTube,
Yeah.
sort of helps make sure that you are sharing the awareness, so that people do know and realize that there is something called an EU settlement scheme which they are to apply to. And most of it is usually done online. And so it's a simple application which is
Yeah.
done either through um, the B, I think it's the UKVI app. So with that app, if you have like a biometric card or a EU passport, it's easy to just scan the passport or the biometric card, and then of course complete the application process on the website. Or if you don't have a biometric card or an EU national passport, you can just go online, look for EU settlement scheme, and apply online. Once you've made the application, you would have to book a biometric appointment if you are a non-EEA national. So EEA
Okay.
nationals do not usually book biometric appointments,
Right.
but non-EEA nationals are the ones that need to have their biometrics taken. So you have
Mm.
your fingerprints done and your photograph taken. And once you've had your biometrics taken, they will send you a certificate of application to say that they have received your application and it's being processed. You can go on and work as you used to, and all your other rights will continue to apply. And obviously, it's not a decision that will come immediately, but it will take some time for that decision to come through. And that
Mm.
would mean that as much as possible, once the decision comes through, you will either be given a pre-settled status, which is limited leave to remain, or settled status, which is indefinite leave to remain. And many people who may not have the biometric card will be given a card, or will be sent a biometric card in due process. But if you made the application with your biometric card and that card is still valid, then of course they wouldn't send you a biometric card, because obviously they would be aware that the card is still valid and it hasn't
Valid.
expired, and therefore they would continue to say that because you have now been granted pre-settled, or you've now been granted settled status, you can go on and work and do whatever you used to do as before. And so, of course, it's a simple application, and they now have the paper form. So the paper form is for those that are not so much aware of using the computer, so they don't really have much of computer skill, or they don't know how to use the internet. And so with the paper form, once you go on to their website for the EUSS form, this is mainly for people who necessarily may not also have an identification, which is a passport or an ID to go by, and therefore they need to make the application as soon as possible. And so the form also helps with that as well. So not just for
Mm.
people who may not necessarily know how to use technology, but those who may not have a form of identification, like children who have just been born, or even children who have lived here but they don't have any form of EU passport or British
Right.
passport, and an
Okay.
application needs to be made for them. So the paper form helps with that. And I know that most people who are under the derivative rights would usually have to call and request for a form. This is different to the EUSS form that has just been, should I say, made available to people. So with the derivative rights application, you would still need to call and request for a form to be given to you before the 30th of June. And then once you've completed the form, you can post the form together with the documents. Whereas those who would usually fill this EUSS form that has now been made available can either post or email that form. I don't know why there's a difference between the EUSS form and the derivative right form, but that is what it is. But they are trying to make sure that people, as many people as possible, make the application before the 30th of June 2021. So at least they are putting things out there so that people can get what you call the paper form or the online form to be able to make those applications before the deadline of the 30th of June 2021. So yes, this is just a little update in terms of our 30th of June deadline. And as we all know, it is a grace period. And if your grace period ends, you should definitely have some sort of reasonable excuse why you were not able to make the application before the deadline of the 30th of June 2021.
Great. Okay, Laura Eunice. You see how much time is taking us to touch
Just
on
do
this
an
again. So that shows how important that is. So, ladies
Yeah.
and gentlemen, viewers, don't let all our efforts go in vain, because we've
Yeah.
spoken about this on a lot of occasions. And
Yeah.
today being our last Saturday before the end of the month, we've also taken time. I think you've spoken about this for the past 12-15 minutes. So
Yeah.
I hope with this, everybody should be okay with it, and we wouldn't have anybody with any excuses saying I didn't know, I wasn't aware. I'm hoping, fingers crossed, that everybody
Mm.
will be okay. Now, Lawyer Eunice, to today's topic, what are EUSS family permits?
Okay. So EUSS, that is also the EU settlement scheme. So it ties in very well with the update that we had earlier on. So when
Yeah,
we talk about the EUSS, it's still to do with our EU settlement scheme that the government has introduced for EU nationals and their family members who are living here in the UK. And when I
yeah,
say living here in the UK, I mean those who came to live in the UK by the 31st of December 2020. So if you are an EU national who came to reside in the UK after the 31st of December, you had no residence in the UK before that time, then unfortunately, the EU settlement scheme does not cover you. So, as they say, the time or deadline was passed by 11 p.m. of 31st December 2020. And
okay,
they said that if you wanted to come and live in the UK, then you would have to apply to the new points based system to be able to live and work in the UK. So
okay.
this is applicable to those that came to live in the UK by the 31st of December
Mhm.
2020, 11 p.m. And so, of course, if we're talking about EUSS family permits, we're talking about those that have applied to the scheme. So if you have applied to the scheme as a EA national and you have been granted pre-settled status or you have been granted settled status after the 30th of June 2021, the law says that they will no longer be known as EA nationals or the relevant EA national, but they will be known as the relevant sponsor. So it means that you are now somebody who is under our immigration rules. And so now that you are under the immigration rules and the EA regulations no longer apply to you, we would now term you as somebody who is a relevant sponsor. And so after the 30th of June 2021, because you have applied to the settlement scheme, you are a relevant sponsor, and therefore, if you want to go and bring your family member to join you who is outside of the UK, you can
Yeah.
continue to do so. And of course, those that made applications under the EA regulation 2016, for instance, would have made an EA family permit application. So usually, people get confused by what's the difference between EA family permit and EUSS family permit. So the EA family permit is to do with applications that were made under our previous immigration EEA regulation 2016. And so if you were to go and make an application to bring your family member to reside with you in the UK, you would make an EA family permit application. But under the EU settlement scheme, you can also bring your family members to join you in the UK. And that is why it's called the EU settlement scheme family permit application. So as of the 30th of June, the government have said that EA family permits will no longer be valid, and therefore it ends on the 30th of June 2021. And so if you have made any sort of application for EA family permit, and of course you are waiting for a response or a decision, then that's fine. But if you are now about to make an application for EA family permit, then you should be made aware that the deadline is the 30th of June 2021, and therefore after that date it will no longer be permissible to make an application under EA family permit. And of course, if you are waiting for a decision, even though they have said it will no longer be valid after the 30th of June 2021, of course, they will have to make some form of provision in terms of allowing that person to enter. And of course, if they do grant that person permit, then that person will be able to travel into the United Kingdom, because of course they would have granted that person permits to do so. So yes, the EUSS family permit is to do with those who are EA nationals or their family members who have made applications under the EU settlement scheme and have been granted either pre-settled or settled status, and are now applying for their family members to join them here in the UK.
Okay, all right. I've got my next asking, is it still possible to make the application after 30th June 2021?
So yes, you can still make the application for
Okay.
EUSS, which is EU settlement scheme, but not for EA family permit. So
Okay.
for EA family permit, the deadline is the 30th of June, and you will no longer be able to make such an application after that date. And of course, we should be made aware that once the deadline is gone, unfortunately, you cannot do anything about it. And so, of course, with the EUSS family permit, you can still apply for your family members to join you after the 30th of June 2021, but not the EA family permit.
Okay. All right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors on Heritage TV and also on BWF Solicitors platform, live on Facebook. Today, the discussion is applying for EUSS family permit after 1st July 2021. You can send in your questions to us for us to, for Lawyer Eunice to answer those questions. You can also call me live on Facebook on 0744 The number again is 0744 Alternatively, you can send me your questions on our Facebook page and all our social media handles. I'll be able to pick them up as well. Also on BWF Solicitors Facebook page. Laura Eunice, who is a joining family member?
Okay, so when we talk about a joining family member, if you look specifically at Appendix EU family permit, which is under our immigration rules, it
Yeah,
defines a joining family member as somebody who is a child of the EA national or their spouse, and
yeah,
that child could be a child who is under the age of 21 or a child who is over the age of 21, and also includes a child who is adopted. So if you have gone through the adoption process and you have a child who is adopted, the adoption should have taken place before the 31st of December 2020. And so, of course, when you look at the definitions, it not only includes a child, it also includes a parent. So it could be the parent of the EA national or the parent of the spouse of the EA national. And you should show that that parent is dependent on you. And so you, the EA national, should be able to show evidence that the parent is being financially supported by yourself, or they
yeah,
used to be accommodated within a household that you lived in, and you are going to continue to accommodate them within the UK. And not only does it include a dependent parent, it also includes a grandparent. So if you are saying that your grandparent is also dependent on you, then you can
yeah.
go ahead and make an application for that grandparent to join you here in the UK. And also includes a grandchild or grandchildren. So if you are saying that you have um, settled status or pre-settled status, and you would like to bring your grandchild to join you here in the UK, as long as you can show evidence that they are your grandchild, as you have
Yeah.
stated, you can also make an application for them to join you here in the
Right.
UK. And then you also have somebody who is a spouse or a dependent, or should I say durable partner. So once you are able to show that that person was your spouse before the
Yeah.
31st of December
Mhm.
2020, or was your durable partner before the 31st of December 2020, you can, of course, make an application for them to join you here in the UK. And as you have realized, the basis for the relationship being formed is that it should have been formed before the 31st of December 2020. And
So
so
you have to show
most,
proof.
yes, you
Okay.
definitely need to show proof. Um, the only exception will be for a child, for instance, who was born out of the relationship after the 31st. So, for instance, you are married to your spouse who you were married to and formed a relationship before the 31st of December 2020. She became pregnant, and maybe in March this year, she had the
Right.
child. That will be the only exception, because obviously you formed a relationship with your wife before that time, and now
Oh,
there's a newborn child, and so of course the child uh, can still make the application for EUSS family permit if they are outside of the UK.
right. Okay. So I think I'll straight away delve into the questions coming in. Laura Eunice, as I try to read my questions, prompt me if you've got any questions on BWF platform as well, so that we can do it together. Yes. Kemi, yeah, says, I have lived in the UK for over 15 years and I would like to bring my two daughters from back home. They are 20 years old and 25 years old. Is it possible to bring them?
Of course. Kemi, definitely you can bring your children to come and join you in the UK. So I'm not sure if Kemi has applied to the EU settlement scheme. And what happens is that because some people may not have yet applied to the EU settlement scheme for pre-settled status or settled status, they may choose to make the application for EA family permit instead because they don't have pre-settled status or they don't have settled status, and therefore they can still make an EA family permit. But where the deadline is the 30th of June, 2020, if she hasn't done the pre-settled or settled status application, then she would have to make the EA family permit application as soon as possible. But if she has done the EU settlement scheme and she's been granted pre-settled status or settled status, which is indefinite leave to remain, then she can make application for the EUSS family permit even after the 30th of June 2021. And so she would need to evidence that these children are her children, of course. And usually we say that a birth certificate is one of the best ways of showing or evidencing a relationship. So if for one reason or the other, they don't have a birth certificate which was obtained during the first 12 months of the child's life, then usually we advise that you have a DNA test done so that it proves the relationship. Usually, I know that with our people, sometimes they will have issues obtaining that birth certificate within the last 12 months, or should I say, the first 12 months of the child's birth. And so it becomes necessary that they do a DNA test. I mean, there are some that will have things like weighing books and personal health record books, which may show the parents' names as well as the child's name. But if there is nothing like that, then it's better that a DNA test is done to prove the relationship. And apart from proving the relationship, she should be able to show that with the child who is over the age of 21, that child has been dependent on herself. And so that includes personal chats or telephone records. It will also include things like money remittances that are made to the child. Of course, if the child is also using the money for things like education, for things like medical bills, those things can also be evidence. And so you can have a letter from the school, you can have the receipts that the school would give for payment of fees. You can also have medical record letters or receipts. So you can evidence things like that from whatever the child is using the money for. If it's to pay accommodation bills, they can evidence that through the receipts that they are given, or if it's to pay for rent and things like that, they can evidence that through the receipts of the rents that are paid. So that will also show that indeed the child is dependent on the mother financially and is also dependent on her emotionally and the rest of it. So it helps ascertain that, of course, this child is actually dependent on the parent as they say they are. So, of course, yes, Kemi can make the application for her 20-year-old daughter and the 25-year-old daughter to join her here in the UK. by proving the relationship that they are indeed her daughters, and then also proving that their 25-year-old is dependent on her. And then once the application has been done online, they can have the biometrics taken, and then a decision will be made in due time for her to have them with her.
Yeah. Lawyer Eunice, with this question, when you were answering it, two things came to mind that I wanted to ask you. You realized that the daughters were 20 to 25. Now, I was asking myself, at what age would they be seen as adults to put in the application themselves? Or it doesn't matter, even if you have a 40-year-old daughter or son, you can still apply to bring them in, provided it's your daughter or a relative.
Yes. So one, should I say, one good thing that was so advantageous for EA nationals and their family members was the fact that there was no age restriction
Right.
to them bringing their family members to join them. So unlike our British immigration rules where the child has to be
Yeah.
under the age of
Age of
18,
18.
with
Yeah.
clear regulations, as long as they were a family member, there was no age
Mm.
restriction whatsoever. And it was so it's so interesting because British people used to think, why do they have that flexibility? And then our rules don't allow for that.
Wow.
So with with the children, there is no restriction in terms of age. So if they are
Mm.
able to show that they are indeed the children of the EA national or their spouse, then
Yeah.
of course they can make the application. The only difference is that once they reach the age of 21, they need to show dependency on the EA national. And
Okay.
so by the rules, we are saying that once the child is over the age of 21, then they need to show some sort of evidence that they are not only financially dependent on the EA national, but there is other forms of dependency, whether it's social, emotional, and the
Mm.
rest of it. And that has come through case law as well, that the dependency doesn't have to be whole, it doesn't have to be entire dependency on the EA national, as long as they can show that the EA national is providing for their essential needs. That's what is necessary in terms of showing dependency. So
Mm.
it's also a flexible, should I say, route for those who are thinking maybe I should go and bring my child over. There is no age restriction that they need
Okay.
to show dependency.
All
Yeah.
right. And the second question, what I also picked up that I wanted you to clarify as well, because it's in connection to our certificate, birth certificates. Um,
Mm,
I had a phone call. I think I referred the person to you. He put in an application, and the Home Office got back to him to say that the birth certificate they are not accepting it, and he knows
mm,
that he got the birth certificate from the registry from Ghana. Now he was very
mm,
frustrated, and I said, get in touch with lawyer Eunice. Um, what is the other alternative? Because if you know that the birth certificate is genuine and the immigration department is telling you we won't accept it, what is the
mm.
alternative? A lot of people from the Afro-Caribbean community, especially Ghanaians, are having this problem.
Yeah, and it's very, very true. So when you first go to, for instance, the birth and death registry, because maybe when you had your child, you did not obtain a birth
Hmm.
certificate, and
Yeah.
so now that it's become necessary for your child to travel, you do need the birth certificates not only to travel, but maybe because you want to obtain a passport for the child. And so
Yes.
you will go to the birth and death registry, get the birth certificate done, and then send it as part of your documents for a passport application. And then once the passport has been obtained, you submit the birth certificate and the passport as evidence of the person's identity and the relationship that they have with the parent. And then you obviously get to the home office, and obviously the home office will do their usual checks, because at the end of every application they request that you allow them to verify and do checks on the documents that you have brought forward. And because you have agreed for them to do those checks, if they do those checks and they find that unfortunately maybe the birth certificate that you presented is not genuine, for instance, and they are telling you that because your birth certificate is not genuine, therefore they are refusing the application. Because let's put it in context. One of the reasons that an application can be refused is because there has been false representation or false documents have been supplied in support of the application. And as you said, you know that this birth certificate is genuine because you followed protocol, you sent your details forward for them to register the birth of the child at the birth and death registry. And they're telling you that no, it's not a genuine document. And you say that it is a genuine document. Therefore, it means that you have to get further clarification from the birth and death registry. So they need to then confirm that this birth certificate is something that they themselves have given to you, and you have followed the due process in obtaining that birth and death certificate in terms of the application that you made. If they are able to confirm it through a letter, even better. You can provide that letter to the home office if, for instance, you were to make an appeal or the rest of it. And so usually if that is the case, then you have to go back to the birth and death registry for them to get a confirmation that it was done following the due process. That's why most of the time we do say seek legal advice before submitting the application, so that you don't go through all these pitfalls before getting the right decision for the person you want to join you here in the UK. So yes, these issues do come back quite a lot, and I think that if there's somebody like that in that situation, they should seek legal advice as to how to go about an appeal, for instance, if that is the case.
Yeah, I also have this, that's my personal opinion. Correct me if I'm wrong, but I've noticed that when you put in an application through a solicitor firm like yours, the possibility of Home Office telling you that this certificate is not genuine, this passport is not genuine, I mean, it doesn't usually happen. But these things are picked up when you individually put in the application. That is my observation.
It's
Because
sometimes
they know the
that's
solicitor firm has done their due diligence.
Yes, yeah. And then what helps is the fact that as solicitors, we also put in our cover letters that the checks have been done. For instance, if a certificate is coming from, let's say, Ghana, and they need to have it verified at the Ghana High Commission as well, we will let clients know that there needs to be verification checks done with the Ghana High Commission as well. So we inform the clients as to what they need to do to have those documents verified even before it gets into the hands of the Home Office caseworker, who will also be looking at that application. So it helps to get advice. And sometimes people may say that they are pocket lawyers, they can do it themselves, and it's simple because it's an online application and they have access to the internet. But sometimes it may not be as simple as you think it is. So it's always good to seek legal advice when making such applications. Yeah.
Okay, great. Ladies and gentlemen, you see, very informative, educative. I mean, if you are here, you are very lucky to be on this platform listening to all the advice and guidance from our seasoned solicitor from DWF Solicitors, Mrs. Eunice Achampong. Lawyer Eunice, before I go to my next question, do you have any before, or do you want me to get on with my next question?
Please get on with the
All
next
right.
question.
Great. Okay. Yes, I've got this question from. Okay, he doesn't want me to mention his name. That's okay. I'm a Dutch national and I have made an application for my children to join me. They had their biometrics 2 weeks ago, and I was informed it will take 2 weeks for a decision to be made. It's just been over 2 weeks and I haven't heard from them. Is there any way I can request for an update?
Sorry,
Hey, why are you smiling?
the reason why I'm smiling is because our home office, as much as possible, we believe that they do a good job, but it's not as fast as 2 weeks.
Okay.
To think that within a space of 2 weeks a decision will be made, yes, I would have said that if you had a very good caseworker who was eager to refuse an application, with most visit applications, you will get a decision within 2 to 3 weeks, but
Okay.
not with EA family permit or EUSS family permit applications, unless you have a really mean caseworker who just wants to refuse and just saw it and just decided to refuse the
You do not get
application.
any commission for refusing. Higher number of refuser.
I'm not sure. Maybe
I'm just wondering.
they do. I'm not sure. They probably do, because sometimes when you see the refusals, you're just thinking
Yeah,
they just
excuses.
wanted something to refuse the application. So maybe if I had some connections in there, I would find out if they do get some commission for it. It's one of those things I always wonder. It's unbelievable. But yes, in terms of EA or EUSS family permit applications, once the biometrics have been taken and documents scanned and submitted to the relevant UKVI decision-making body, they will try and make a decision within 12-week period. If you are blessed enough to have a caseworker who is able to look at it within a period of 4 weeks and grants a decision, then that's even better. But I think in this case, he just needs to be patient, and they will make a decision as soon as possible for the family members to join him here in the UK. It's one of those common questions, because people are always thinking there should be a decision as soon as possible, because I've gone for my biometrics. Why is it taking so long for a decision to come? And I think it takes even longer with the in-country ones. So he should be rest assured that there will be a decision, and once he has let the family member go for the biometric appointment, sooner rather than later there will be a decision. He just has to be patient to wait for that decision.
Eunice, how long is too long before you get back to them to say, I've waited for the past 2 months. You said 2 weeks. I have waited for 2 months. What is going on? What is happening?
Yeah, so in terms of applications made for family members who are outside of the UK, if, for instance, you believe a period of 12 weeks has passed, you are saying that it has taken more than 2 weeks, they would usually have sent an email if, for instance, 2 months has passed and they still haven't been able to make a decision. If they haven't sent any email to that effect to say that they are going beyond their normal standard period of service, then it would mean that you can also try and contact them. I know people would use the TLS contact because sometimes with TLS they will say you can look at the progress of your application, and TLS is a middleman, or should I say they are a secondary service to the Home Office, because they are there to enroll people's biometrics and to scan the documents and upload to the Home Office. So usually when they say you can follow or track your application, they would only have information as to when the application was submitted, the fact that they've uploaded the application to the Home Office and it's still in progress. And then if a decision has been made, they will also be the ones to inform the applicant decision has been made. So they are there through the three stages. But in terms of an application being in progress, they can't really do anything about it because they are not the decision making body. So usually, I know people will try and track the progress of the application through the TLS contact website. But outside of that, if you have a solicitor who is making the application on your behalf, they too can also email the relevant decision-making body to find out if there is any progress in terms of that application. But in most cases, I will say do allow for a period of 12 weeks when you make the application.
Okay. All right. Right. This is an EEA question. I made an EEA family permit application for my children, and the application was refused 2 weeks ago. Can I appeal the decision? Ines.
So this question seems simple, but it's actually in two parts, because when you look at the fact that the person is saying that they've made an application for their children to join them, they've not only made the application for the children to join them, but they made an EA family permit application. So that means that the EA family permit application that was made for the children, if they had pre-settled status or settled status, they wouldn't have had to make an EA family permit application. They could have done the EU settlement scheme application for them straight away. And of course, if they have now got their pre-settled status or they have now got their settled status, they can now make the application for the children to join them by applying for an EUSS family permit. So, of course, if they do have that, then I would say they can make a fresh application for an EUSS family permit for the children to join them. In terms of the appeal, they are asking, can they put in an appeal or lodge an appeal? If for one reason or the other they have not been able to get their pre-settled status or their settled status and they're thinking about lodging an appeal, then yes, of course, you can lodge an appeal as soon as possible. Most people are thinking because the deadline is the 30th of June, if they are not able to lodge the appeal, then that would mean that everything is done with. They can't really do anything else about it. If it is the case that you have been given 28 days to appeal and you have the right to appeal, of course, I would say that then you can use that right of appeal, because it is based on when the application was submitted. And if the application was submitted before the 30th of June, a valid application was made using the right processes, and you have also enrolled your biometrics before the 30th of June 2021, then of course all the due processes have been followed and you can lodge an appeal within the time frame of 28 days that has been given. And it would be as if your application were still pending because no final decision has been made. So,
As
of
in,
course, you can still make the application, I mean, the appeal to then go on to the courts for the courts to make a decision on the matter. Whereas if you have pre-settled status or settled status, then I would say it is better to make a fresh application under that route, and then obviously, depending on the reasons why it was refused, address those reasons again in a cover letter, and then, of course, wait for a decision to be made on that basis.
okay. All right. Laura Eunice, I think that's the last question from my end. I think
Okay.
Ezekiel on the PWF solicitors
Yeah.
portal has asked the question. If you can just read it and answer it for him, please.
Okay, so just before Ezekiel, Michael J says, please, I applied for EU family permit. My biometrics is in July. Am
Okay.
I supposed to go with my original documents or just my passport, please? Um, I'm not sure whether he's referring to an EUSS family permit, but I'm assuming
Mm,
that he's applied for an EUSS family permit, and
okay.
he says he's got his biometrics in July. Of course, if he's got his biometrics in July, that's fine. Once he's booked the appointment to go, he should go with all the original or relevant documents. So let's say that he's made an application for um, should I say, spousal visa. So he's going to go with his marriage certificate, which shows that they were married before the 31st of December 2020. He's going to go with any sort of evidence that shows that their relationship is indeed subsisting or is continuing. So, WhatsApp communication, phone call history, any sort of thing that will show that their relationship is still ongoing. So sometimes some people will have travel itineraries and boarding passes um, from the spouse who is here in the UK, and
Oh,
money remittances and things like that will also help as well. So any sort of evidence that shows that the relationship is still ongoing can be provided for them to make a decision on the application. So yes, he should go with his passport, a copy of the passport of his spouse, for instance, and
mm,
then evidence of the spouse's settled status or pre-settled status, and any other documents that show that the relationship is still ongoing needs to be taken to the biometric appointment so that they can scan and upload it to the home office in due time as well. And
okay.
you said Ezekiel, isn't it?
As Ezekiel, yeah.
Ezekiel says that, good afternoon, Lawyer Eunice. Can you kindly explain these two concepts for us, and more so as it applies to immigration or naturalization applications? This stems from the idea that a criminal offense does not expire and one can be prosecuted for a criminal offense even decades after they take place. Can you explain this idea versus the concept of statutory limitations versus spent and unspent convictions? So his question is quite long and it's theoretical.
And
And so I would say to Ezekiel, please, please call me privately. If
yeah,
it's to do specifically with naturalization, as we spoke about last week, then at least that will help our viewers in terms of that. When it's
yeah.
quite general like this, unfortunately, most people will not be interested. So, Ezekiel, you can call me after the program and I will leave my details behind for you to do so. And lastly, we have Mo who says, please, I have my son here who came from Ghana with a visitor's visa and I am an EU citizen. How can I apply for his residence? So very
BTG.
quickly,
Is it regarding the program? Okay, hold on for
no,
me a minute. Yeah.
Oh, okay. So in terms of most question, obviously, if his son came here on a visit visa and he is now thinking about making an application for EU settlement for his son, he should be able to show that since his son entered the UK, his son has depended on him. And I'm guessing his son is probably over the age of 21. If his son is under the age of 21, that would be much simpler to show that um, that is his son, and therefore he is making the application for his son to have pre-settled status to reside with him, or settled status if Mo himself has settled status here in the UK. If it is the case that Mo's son is over the age of 21, then he should be able to show that he has depended on his on Mo since he came here or he resided here in the UK. And so that would include financial support, maybe bank to bank transfers. You should be able to show that you have been supporting him financially, and you should be able to show that he is in one way or the other dependent on you. So it might be that he is not working, he is unemployed, and of course, you are providing him with the financial support that he needs. You are providing him with accommodation, you are providing him with the necessary things that he needs to be able to, should I say, survive and live in the UK. So, Mo, you can give me a call after this program, as there isn't much detail in your question, and then we can take it from there.
All right. So I've got a caller on the line. Hello. Hello, sis. Mpacho, good afternoon. Okay. No problem. No problem. Obi obetimi akatwi. Mpacho ya fra osen wo fra fi he.
London, maybe
Ama, you Ama. Okay.
My question is me too.
Okay.
Now, first one, me aware na the ama me, but my didn't definitely to me for settlement status 2018. Yeah. But in the same way, my submitted for replacement biometric card. Last 2 weeks, na me too quiet Kogan and I'm going to change to line. Okay. In this case, no, na me submit no, minimum connect divorce. The marriage certificate, no more say me fact prove a certain minute EU partner. It's nine. How long we need to the marriage certificate in time now? 2013, the next home. And at the same time, we didn't divorce certificate now. My 2019 address no.
Yo.
And I'm saying, in this case, no, me not a divorce, no, refusing and by many pressure to indefinitely.
Okay.
And I'm replacement card biometric and I'm making.
Okay. If I told on maybe Salwa Eunice, did you hear what the question she asked?
That she made a replacement biometric card application, and she wants to know if she will be refused because she retained her rights after the divorce of her EA national spouse. Is that correct?
No.
That's right.
Aha.
No,
when you're indefinite. No. Okay. Into any first question, no. Into my lawyer answer first question. What my second question? Anna.
Okay. Next second question. Yes, you make worry. Make at the same time make worry. It's not to say me see the man I man indefinite and I say the man a day. Because I think I may start making inquiries.
Okay. Me patcho.
DWF number 10 me measurement for ya no also that.
Okay. Why are they?
The man for me na
patcho you.
The man
okay. Okay. You me patcho, hold on now, lawyer Eunice. Lawyer Eunice, so you've got the second question as well.
Yeah.
Okay.
Yes,
so
the second question is to do with the husband.
With the husband, she's going to be married. Yes. So let's touch on the first question, then the second question. Finally,
okay.
Whichever one you want to.
No, that's fine. So, in terms of the first question, when you make a replacement biometric card application, Usually, it's a simple application. It will ask you whether you already have a biometric card. So if you have the biometric card, it will ask you for the details. And once you put in the details and your basic information, of course, it will just ask for the postal address that you want the biometric card to be sent to once they've approved the application. So it's just a replacement. It has nothing to do with whether they are going to grant you pre-settled status or whether they are going to grant you settled status, because that is the, should I say, the main application process where you have to prove that you've retained your rights and that you were married to the EU national for a period of 3 years and you live together for a period of 1 year. That has nothing to do with the BRP replacement. So once you do a BRP replacement card, all they want to know is, have you applied to the EU settlement scheme? Have you got pre-settled status or settled status? So that they can put that on the biometric card when it arrives. So that those are the simple information they need. And she says she's already gotten her settled status. So they will just put her settled status onto the biometric card. So it's not an application for refusal. They are just going to take the information she has given and put it on the card that she will now be getting after the application has been decided. So it's not an application for refusal. It's just to replace the old card that she has. And in terms of the second question is to do with the fact that she's now going to get married and she wants to know what her husband will get once he has made the application for him. Now she's saying that she's not the EU national herself, she's the non-EU national. And basically, if she's making the application, she's not making the application under the EU settlement scheme. She'll be making the application under our immigration rules as somebody who is settled here in the UK. Because she's a non-EA national, she is basically saying that as a non-EA national, she's lived in the UK, she has been granted settlement, and therefore she would also like to bring her husband to come and live with her in the UK. So usually she'll be making this application as a family member. So she will make an application for a spousal visa for her husband to now join her in the UK. And under Appendix FM, you have those 4 requirements: that the relationship is ongoing, or the relationship is genuine and subsisting. You have the financial requirement that she should be meeting 18,600 a year, that she should be able to provide accommodation which is suitable for the two of them, and that their partner who is in Ghana should also be able to show that he has done the English IELTS at least at a level A1. So these are the 4 requirements that have to be met so that he will also be granted 2.5 or 2 years 9 months when he's basically made the application and they've decided to grant him leave to enter the UK. So she will not be making the application under EU settlement scheme because she's not an EU national, but she will be making the application for her spouse to reside with her because she has settled status here in the UK.
Okay. Mepacho, we are satisfied with the answer. Okay. All right. Thank you very much. And to say, who any further, who need further assistance? Send your also refer Crawford to BWF solicitors. You can get in touch with lawyer Eunice, and she'll be very glad to support you with any advice. Why? Okay. We wish you all the best. Thanks for calling us. Okay. Bye-bye. Yes. Ladies and gentlemen, my apologies speaking the local dialect because that was what she was comfortable in asking the question. She wanted to be able to explain properly what her question is. So as I was speaking in the local dialect, she said she's very satisfied and happy with the answer lawyer Eunice gave her. And I also advised if she needs any further assistance, she should she shouldn't hesitate to contact lawyer Eunice for help and advice. So, Lawyer Eunice, I think we've exhausted all our questions. Any final words and contact details? Before I do that, let me quickly, like I always do every Saturday, BWF solicitors also have this community program where they, like what I'm doing with Lawyer Eunice, they also do something similar. 4 o'clock every Saturday on their Facebook page at BWF Solicitors. And I think today's topic is how to make a successful British naturalization application. So tune in at 4 p.m. today on the BWF Solicitors platform. And you'll be very happy you did. Share, inform all your loved ones, colleagues, family and friends to join in this educative program. So over to you, Lawyer Eunice.
Thank you so much, Vicky. So yes, in terms of this EUSS family permit application, as I have just said, you can make these applications even after the 30th of June 2021. So if you have any spouse, children, parents, grandparents, grandchildren that you think that they need your support and you want them to come and join you here in the UK, you can continue to make those applications even after the 30th of June 2021. Please do not hesitate to contact myself or the law firm. The law firm is situated in London. Our address is the 4th floor of Anna House. So BWF Solicitors, 4th floor, Anna House, 214 to 218 Tottenham High Road, London, and the postcode is N154NP. So N154NP. Our telephone number is 0208 493 7340. So 0208 493 7340. And my personal contact number out of office hours are 075 35 81 3910. So 075 35 81 3910. Thank you so much, Vicky.
So on that wonderful note, Lawyer Eunice, we thank you so much as usual for taking time off to come on this platform to educate us. We very much appreciate it. Ladies and gentlemen, we've come to the end of this program. We'll definitely see you next week, Saturday, with another interesting topic. If you want to watch this program again or want to share it with those who, were not available to join us, during this live program, you go on our various Facebook pages. A recorded version will be there for you on BWF Solicitors Facebook page and also Heritage TV Facebook page, and you can listen to it again. Take good care of yourself, and we'll definitely see you next week, Saturday, same time. Eunice, thank you. Have a great weekend, and have a lovely weekend, everyone watching us. God bless. Bye-bye.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.